So just for a refreshing change, we get to actually look at motions that have been made by the Assistant State Attorney as opposed to the 72 motions made by Ms. Burden. So I thought before I jump in and talk about the 2 motions that have been filed by the State or Assistant State Attorney, I should actually let you know who she is. So this is Assistant State Attorney Danielle Pennell, and you're going to see her name on quite a lot of motions and things from here on in, I believe. I think she is going to be the one fighting this case. Obviously, Monique Worrell is like the big boss in terms of, state attorney. She employs these guys and, makes all the big executive decisions. These guys are the workers. So, just to give you some idea of her background first, she is clearly highly experienced and quite knowledgeable. So we have here, I am currently a prosecutor assigned to the Homicide Unit. I have previously held the role as Deputy Bureau Chief. I've also previously handled special victims crimes, including S crimes, domestic violence crimes. I've prosecuted general felonies, juvenile crimes, misdemeanor crimes. She's done a lot. She's got a lot of experience, and she's the one that locked up this Todd, I'm not sure how to pronounce it, the guy who basically killed his entire family and dog. She was the prosecution in that case and had a successful case with that, which also shows that she has worked with Judge Carson, who is the judge in this case. So they obviously understand each other's rhythms in terms of professionalism. So I think that's going to go a long way to helping her out with making sure that she wins both cases. Now, on that said, before I jump in and talk about the 2 motions that she has filed this week, I will just say that old Lizzie Borden, no, I shouldn't keep saying that, Beth Borden has filed yet another motion, this time requesting that essentially the judge throws away actual Florida law and says that unless there is a unanimous decision by the jury, that the DP will be thrown out. I think from memory, from what people have told me, is that you can have 8-4. So if you have 4 jurors who aren't in favour of the DP, but you have 8 who are, I think then the DP still will proceed. But what this latest motion from our friend Beth is, basically she wants a unanimous decision from the jury. So she wants to create her own laws in Florida. Meanwhile, it seems that the Assistant State Attorney has somewhat efficiently put in 2 motions against motions made by the defence team. So I'm going to go through them just quickly because I think they are quite succinct and I think they give us an idea of what we're going to see in the courtroom. I think we can expect a decent trial. Now, as you are no doubt aware, grand jury is always kept secretive. It is not something that is made public, and it is not something that is normally disclosed to the defendants. It is not something that is used as an argument in trial. It is simply what is used to decide when an arrest is going to be made, essentially. In Stearns' case, it was the decision that he would be arrested and up on charges facing the DP. Well, actually, The motion to have the DP introduced came after this. Their job was basically to have him to have him arrested for red rum. It's so hard sometimes trying to get everything right for YouTube. It fries my brain. Okay, so the defence team have come out with a few motions where they wanted basically to be given all the information on the grand jury. They want to find out the list of witnesses that were used for the grand jury. And they want everything from the grand jury. And I believe they also wanted to use part of that in relation to the actual trial. I can't remember what the actual thing was, but I'm sure it will come up in this motion, so I'm not going to review it. So this motion, I think the title is almost as long as the actual motion. State's motion to strike to defendant's motion for disclosure of list of witnesses who testified before the grand jury, and State's response to defendant's motion for disclosure of list of witnesses who testified before the grand jury. So it's pretty clear where we're going with this. Comes now the State of Florida by and through the undersigned Assistant State Attorney and states and alleges the court should strike the defendant's motion as legally insufficient, and I think we're going to hear this quite a lot, because it is predicated on nothing but surmise and speculation. And she's playing the quoting game as well in terms of precedents, but at least she's not quoting 50 million precedents for everything. It reaches the conclusion that his request is necessary to ensure his due process rights, to effective counsel and a fair and impartial jury without any factual support as to why. This motion does not contain a sworn allegation that a grand jury witness's testimony is materially different from other testimony given by the witness. So there's another case that's cited there. To pierce the veil of secrecy involved with the grand jury proceedings, specific factual allegations need to be made by the defendant. In other words, you can't just ask for the list of witnesses. You need to have allegations against one of those witnesses, and you need to prove allegations. The unusual secrecy of the grand jury proceedings is the result of centuries of experience. It helps protect the indictment process from interference by thugs. I like that. It is certain the minutes of the grand jury proceedings in this case were properly kept, inviolate. In other words, there was no tampering with the grand jury. There is no evidence of tampering with the grand jury. Hence, the defence has absolutely nothing to go with. Having failed to establish a proper predicate, a strong showing of particularised need, respondent was not entitled to disclosure of the grand jury witness list or minutes. There has been no particularised showing of the defendant's need for the grand jury witness list or minutes. In fact, this identical motion has been filed in several cases. I love the efficiency of this file. This lawyer knows what she's doing. She's not faffing around with 30 pages of utter BS. She's straight to the point. She lists the various cases that are relevant and then moves on. So she's actually listed 4 precedents here. Therefore, the court should strike the defendant's motion as legally insufficient. If not, the court should deny the motion on its merits for failure to satisfy his burden to show a strong particularised need. And she's also sent a copy of that to Elizabeth E. Borden. So, short and sweet. Basically, she's essentially said, look, this request for the list of witnesses from the grand jury, there's no legal reason for them to actually request it. So the second motion, State's motion to strike defendant's motion for transcript of grand jury proceedings, and State's response to defendant's motion for transcript of grand jury proceedings. So I think what we're going to see is that the more ridiculous motions that have been made by the defendants are just going to be swatted down quite succinctly, I would say. Comes now the State of Florida buy-in through the undersigned Assistant State Attorney, and states and alleges as follows. 1. The defendant's motion is legally insufficient and the court should strike it. I hope they have this in a template ready to go, because I think they're going to be using this argument quite a lot. The motion is grounded on nothing but mere surmise or speculation, rather than facts which support things such as allegation that the state had withheld critical facts from the jury. A request to review the transcripts to ensure no witness committed perjury before the grand jury is legally insufficient if the defendant does not provide a specific basis to conclude any grand jury witness committed perjury. Nor is mere surmise or speculation that a witness's testimony at the trial is inconsistent with that given before the grand jury to lift the veil of secrecy from the grand jury proceedings. None of these have been alleged by the defendant. So basically there's no legal grounds for them to be requesting any of this. The defendant's motion essentially boils down to, it would be potentially helpful. It is therefore based on pure surmise or speculation, if not on curiosity. The defendant has not alleged a particularised need. In other words, she's just going, please, can I have a look? It's none of my business, can I have a look? So, yeah, I love how succinct this motion reads. It's easy to understand, and it's not full of all the crazy waffle that you get from the defence. Even if the defendant lays the proper predicate for grand jury transcripts to be produced, the proper procedure is for the court to then conduct an in-camera inspection to see if the defendant's allegations are accurate. Meaning that if there was some sort of allegation made by the defence, that's not reason for handing over all the information to the defence team. It is then something that is looked at within the court. It is not, doesn't give them free rein over information. Contrary to the defendant's assertion that disclosure of grand jury testimony is appropriate under the law, the case law makes it clear that Florida statute requires the court to strike his motion as legally insufficient. Keene v. State provides no support for the defendant's argument. In fact, it requires the defendant to show a particularised need sufficient to justify the revelation of the generally secret grand jury proceedings. The defendant's motion is a boilerplate motion. It's being filed in multiple cases. I'm sorry, and I'm not going to edit that out either. I think we could have guessed it. It's being filed in multiple cases in the 9th Judicial Circuit. So, I'm not sure if I had commented that it seemed like it was just something that she was pulling out, boilerplate basically. But Now we know there are 4 other cases that Ms. Burden is covering, and she has filed the exact same motions for those 4 other cases. Well, oh my gosh, it just goes to show, doesn't it? She's probably just got this whole folder full of motions that she just files for every single case, which would explain how she can now be up to, I believe, 72 motions, because they're already there. She just pulls them up and goes, which one am I going to send today? My gosh. I'm so glad that I decided to do this quickly tonight before settling down for the evening, because this is just way too amusing. The defendant next turns to citing examples of prosecutorial misconduct. Unfortunately, the defendant then makes the generalisation that this makes it likely to be occurring in this case, without any evidence to support his claim. I really hope this whole trial is televised, because I think this lawyer is going to be one to watch. I think her arguments are going to be brilliant, and I think every piece of drivel that Ms. Burden comes up with, I think we can expect this assistant state attorney to just smack her down. The defendant utilises case law citing improper closing arguments, discovery violations, and defying court admonishments to support a generalised allegation that disclosure is necessary in all cases. The defendant's motion is legally insufficient as it fails to state a particularised reason why his request should be granted by the court. In other words, you can't just ask for something which is normally protected under the law and expect the judge to just throw the law out the window and say, yeah, sure, here you go, let me hand it to you now, even though you haven't got any legitimate reason for me doing so. 9. The defendant further argues that grand juries are required for capital crimes, and because capital crimes require a sentence of life in prison, or the DP, the disclosure of grand jury testimony is required. Courts have repeatedly held otherwise, absent showing of a particularised need. In other words, she ain't got a leg to stand on. You can't just ask for disclosure of grand jury testimony, because unless you have proof of something that requires it to occur, then the law says it doesn't have to happen. If you have proof, then it leads to an in-camera inspection. It's not disclosed to the defence. Paragraph 10. Pennsylvania versus Ritchie granted Mr. Ritchie's request for an in-camera inspection of DCF records because of the compulsory process clause, not the confrontation clause. Basically, she's now correcting the errors made in Ms. Burden's motions. So it seems that Ms. Burden hasn't even got her legal facts correct. Furthermore, Mr. Ritchie's request was specific that the DCF records might contain names of witnesses. Ritchie, of course, may not require the trial court to search through the CYS file without first establishing a basis for his claim that it contains material evidence, citations admitted. I'm not sure you'd have to know that specific case to know what's going on, but essentially she's saying you got it all wrong anyway, sod off, Baldrick. Paragraph 11. In summary, the defendant claims that disclosure of grand jury testimony is required in every case presented to a grand jury. This is not a particularised request. This is a blanket request to overturn long-standing precedent. In other words, you're basically asking for the law to be changed just because you want it to be. Paragraph 12. The court should strike the defendant's motion as legally insufficient, otherwise the court should deny the motion on its merits because it fails to allege any specific grounds beyond mere surmise or curiosity. And again, a copy has been furnished to Elizabeth E. Burden. I think it's Burden. So, I think from looking at these two motions, I think we can actually feel quite confident that the Assistant State Attorney has a far better grip on the law than Ms. Burden, and that all these ridiculous motions that have been filed thus far are just going to be slammed down one after the next. And I think this definitely gives me confidence that we're going to see a good trial, and that all these silly little stunts by Ms. Burden are not going to go anywhere. We know that the judge has a really solid understanding of case law, of precedents, all that sort of thing, and it appears that Ms. Pinnell also does. So I feel reassured, and I hope this makes everyone else feel somewhat reassured also. I'm actually looking forward to seeing more of her motions, because I think she is going to very succinctly sit Ms. Burden on her arse. So on that note, this was just a quick one because I did want to just have a look at how these motions read and see if that gave us an idea of what to expect, and I think they do. So thanks for listening. If you are new to my channel, please subscribe. Also, please hit the like button and leave a comment below. What are your thoughts on these motions filed by the state? Do they give you confidence that we are going to see a fair trial for Maddie?